Why is statutory interpretation necessary and fundamental to the legal know-how? Lawyers and judges need to interpret the laws frequently. They may include primary and secondary legislation and contractual and commercial documentation. Principles of statutory interpretation help the students of law and the legal professionals to make sense of the legal documents within the boundaries set by the laws of the land. There are several reasons why statutory interpretation is necessary. Let's discuss all those reasons one by one. They are the main reasons. Number one, in order to resolve uncertainty in the law, the statutes are required to be interpreted in a consistent manner. So there is element of consistency. The laws are made for the general public, and the public should feel confident in their dealings without fearing unexpected results of any subsequent litigation. For example, in the case of R against Secretary of State for the Environment, Transport and the Regions and another ex parte Speth Home Limited, Lord Nicholas stated that citizens, with the assistance of their advisers, are intended to be able to understand parliamentary enactments so that they can regulate their conduct accordingly. Similar point was made by Lord Diplock in the case of Father Gill against Monarch Airlines Limited in the following words: "It would be a confidence trick by Parliament and destructive of all legal certainty if the private citizens could not rely upon that meaning, but was required to search through all that had happened before and in the course of the legislative process in order to see whether there was anything to be found from which it could be inferred that Parliament's real intention had not been accurately expressed by the actual words that Parliament had adopted to communicate it to those affected by the legislation." Point number two, words and terms used in legislation may cause serious problems and may result in unintended and obnoxious consequences. Usually, and depending upon the context, words may have more than one meaning, equally relevant and capable of interpretation in the given legislation. This may cause serious difficulties for the courts and the litigants. Point number three, there may be a change in the language used in a statute, and the meaning of the words may change over time. The rules of statutory interpretation help the courts to deal with such issues. Point number four, a parliamentary statute may contain errors and issues. The mistakes may go unnoticed during the legislative process, in particular where the bill has been amended several times. Point number five, development in technology means that the courts may need to cover the modern day situations while applying the old statutes. For example, the courts included telephones when interpreting Telegraph Act 1869, despite the fact that telephones were not invented at the time when the statute was passed. Point number six, legislation may fail to deal with all eventualities and specific circumstances. Point number seven, some words and terms may be applied and some rules may be presumed in relation to a statute. The courts need to give meaning to the statutes in light of the presumptions and implied meanings of the words and terms. Now that you have been introduced to statutory interpretation and why it is necessary, there are a couple of exercises to help yourself. First exercise is about summarizing the principle of statutory interpretation as laid down by Lord Diplock. And the second exercise is summarizing the importance of the statutory interpretation. Please refer to the following lecture to see the exercises and what is it that is expected of you. I will see you in the next lecture.